Damien O'Connor.
Thank you, Mr Chair, and I didn't want to cut across my colleague. Mr Chairman, this is a very important part of the legislation, and I just read an article online that talked of a case currently before the courts where the owner of a forestry logging company is subject to prosecution.
The member's going to take care, isn't he?
Absolutely, no, I will not go into the detail, but I think the principle is that the person involved thinks that they may be set up as perhaps a scapegoat, as an example, by a government that has a new focus on health and safety. The point being that whatever we do in legislation and whatever we change here, the one thing that Kiwis want is fairness. So the devil is in the detail, and I know that people watching and listening may think we're being pedantic about words and about interpretations of them. But the fact is that we are trying to pass a piece of legislation that will not only provide safety and protection for all workers, but also to provide fairness for all employers. And I think that is equally the objective of the Labour opposition as it is of the government. So fairness and equity is important. So when it comes to the issue of enforcement and other matters, and I'm sure that it's an issue that will be in the court of the law, is that is the person before the court getting a fair go, or has, as has been pointed out in this debate, has the decision to prosecute, which seems to be a somewhat subjective one, given recent history. That is that the department decided it couldn't proceed, yet the private prosecution by the CTU proved that not only could they do that, but they could do so successfully. I come back, Mr Chairman, to part 4, which is enforcement and other matters, and I'd just like to go to a part of the bill that he did kind of strike a few chords with myself, and that is over the limitation periods for prosecutions. And some may see it the get out of jail free clause. And Mr Speaker, for the families of Pike River, this is a particularly pertinent area where delays in the process have effectively rendered their inquiry or their desperation, I guess, for some justice a null and void, because of course, the mine managers are unlikely to be taken to court at all, Mr Speaker. As pointed out by my colleague, Ian Lees-Galloway, the limitation periods are really important. And it's not only with big, terrible, tragic disasters like Pike River, but with other complex cases of accidents and perhaps death in the workplace, there will sometimes be quite a period of investigation. And this does say 6 months after the date on which the coroner completes and signs a certificate of finding. So there's some acceptance that there must be some conclusion here. But if you look at a major, I guess, disaster, you've got a recovery period. You had a royal commission in the case of Pike, and then there was, I guess, decisions around whether to prosecute by government agencies or police. And I think the SOP, or the amendment being put forward by my colleague, is indeed a very necessary one, so that at the end of a decision, at the point of a decision by a government agency, that doesn't effectively eliminate the right for private prosecutions to occur. And as we've seen with the CTU, their involvement, they can be quite successful. And it's not that New Zealanders, want utu or want revenge, but we must ensure that there's a fair process of justice all through this health and safety legislation. As I say, to ensure that, firstly, we get proper protection for the workers. That's our first and foremost objective. But then, should an accident occur, if indeed the employer has done all he or she can, if the PCBU or the BOSS, as my colleague Kelvin Davis says, if they have done all that they can, then they're not unjustifiably, I guess, taken through the courts and prosecuted. But at the same time, anyone who does not do what they should do should rightfully be subject to the full force of the law and all the provisions that are laid down in this. Mr Chairman, if I might ask, just going to clause 178 here, And Mr. Chairman.
Damien O'Connor.
Thank you very much, Mr. Chairman.
With a warning to keep the focus tight on part 4.
I appreciate that, Mr. Chairman, but they are quite, I know they are technical, but they are far-reaching
Yes,
clauses
I understand that.
and
The member's done
implications
better
from
than some of his predecessors.
This clause says, state of mind of directors, employees or agents attributed. And while I was not part of the select committee, and I imagine that there are some explanations, and maybe the minister can explain these things, it's a little bit confusing here because it said in any civil proceedings under this Act, it goes on to say, it is necessary to establish the state of mind of that individual. It is sufficient to show that the employee or the agent of the individual acted within the scope of his or her actual apparent authority. It then goes on to say in this section, state of mind in relation to person includes knowledge, intention, opinion, belief or purpose of the person and person's reasons for that intention. In summary, Mr. Chairman, and I'm not trying to be flippant, it is quite a subjective clause in my view, and clarification will be needed to ensure that when applying this, any agency that is implementing the law does so in a fair and unbiased way. And I'm not sure whether this applies directly to a situation on the farm, but if you're looking at state of mind, I can assure you, Mr. Chairman, that farmers, particularly dairy farmers, in the middle of spring, facing the dilemmas that they do at the moment, will not be in what we might otherwise say a balanced and sound state of mind. They are under pressure. They are under huge pressure, and I'm not sure who's going to be the judge of that, whether that is a sound state of mind when making decisions regarding workplace safety. And it comes right back around to a question that I asked, Mr. Chairman, and again, it is not flippant, that in the issue of farms, high risk or low risk or whatever, does state of mind, and the definition is laid down in clause 1783, does that leave the door open for subjective and I guess variable interpretation that might mean that some farmers are going to get prosecuted or be subject to prosecution and others aren't, depending on how stressed they are. And the absence of any workplace representative in a farm environment because of the government's changes may make huge changes and differences to that application there. If you have, I'm assuming in a workplace, someone who is an employee who's delegated or appointed or indeed can be elected as the workplace health and safety representative, as an employee they probably have less stress than the business owner. And in the case of a farm, as I said at this time, they will be very, very stressed. So the issue of how someone, a court of law, a judge ultimately, determines the state of mind in relation to a person, including the knowledge, intention, opinion, belief or purpose of the person and person's reasons for that intention, opinion, belief or purpose. It is quite confusing when read out like that, but it is a clause in this that needs clarification, Mr. Chairman. Can I just go back to say that, as I say, we believe that every clause in this part of the bill needs to be clear to protect employers. And the protections for the employees are through other provisions of the bill, ensuring representation, ensuring the right classification. So those aside, this is about a fair go for employers, and there'll be people out there who think that the opposition is only seeking to protect the employees. That's not the case, Mr. Speaker. We have to have fair, effective and implementable and reasonable workplace health and safety here, but it must be effective. And my reading of this is that that does leave the door open for what is a very subjective question. The Minister can answer it, of state of mind and who's the person who's going to be assessing that. Is it indeed a psychiatrist, or will it just be the implementing officer, Mr. Speaker, the enforcement officer, or indeed will it be, the employee?
I call